I'm Greg Coleman, President of the Florida Bar. Welcome to the second installment of the Florida Bar's Social Media and Technology series. This is the second webinar in our three-part series designed to bring lawyers up to speed with technology that will assist them in their practices. Now that you've learned the basics of using Facebook, LinkedIn, and Twitter from Ethan Wall, you need to know how to properly use those social media tools in compliance with the rules regulating the Florida Bar. So today, Attorney Mac McCoy of Carlton Fields, Jordan & Burt has designed a special presentation to educate you on the potential ethical pitfalls for legal professionals using social media. Mac's presentation, entitled Legal Ethics 2.0 OMG, will address the rules of professional conduct that apply to professional and business activities on social media, the uncharted territory of legal ethics, regulation in the social media realm, and things to consider when you're using social media personally and professionally. We hope this presentation helps you in your journey to incorporate technology and specifically social media in your practice. Enjoy and thank you.
Hello, my name is Mac McCoy. I'm a shareholder and business litigator in the Tampa office of Carlton Fields, Jordan & Burt. I'm honored to present this second installment of the Florida Bar's Technology Webinar Series. The topic of this webinar is Legal Ethics 2.0 OMG, Potential Ethical Pitfalls for Legal Professionals Using Social Media. For the past 5 years, I've been on a personal mission to help educate fellow lawyers, law firms, and other legal professionals about the various ethical implications of using social media. As Ethan Wall explained in the first installment of this webinar series, Social Media Marketing 101 for Lawyers, social media can be a highly effective tool for business development and legal marketing. It can also be a highly effective tool for research and information gathering in your day-to-day legal practice. However, many lawyers and law firms simply have not paused to consider fully the ethical implications and potential ethical pitfalls of their social media activity. In this webinar, we will cover 10 such pitfalls, including a brief discussion of the Florida Bar's advertising rules and their application to social media. Registrants for this webinar may also download a PDF of a substantive presentation outline containing citations to the ethics opinions, ethics rules, case law, and other authority I've collected over the years relating to each of the pitfalls. You may wish to download the outline and save it for future reference in the very likely event that you encounter any of these ethical issues as you continue your social media engagement in your law practice. Let's start by defining what we mean when we refer to social media. For purposes of this presentation, we'll define social media as any online or mobile technology that promotes communication, collaboration, and the sharing of content between users. As you might imagine, that encompasses a broad array of online and mobile technologies. It includes social networking sites like Facebook and LinkedIn, location-based networking sites like Foursquare, blogs, microblogs like Twitter, wikis like Wikipedia, photo sharing sites like Flickr, video sharing sites like YouTube, Vimeo, and Vine, and document sharing sites like Scribd.
For purposes of this webinar, we will focus on 4 primary social media sites: Facebook, LinkedIn, Twitter, and YouTube. Facebook is the world's largest online social network with over 1 billion monthly users across the globe. Many lawyers and law firms use Facebook for legal marketing and investigative purposes. Many lawyers also use Facebook for personal purposes, like sharing family photos and information about personal activities and interests. LinkedIn is one of the world's largest professional social networking sites with an international user base of over 300 million professionals. LinkedIn also happens to have a relatively high adoption rate among lawyers and law firms seeking to establish a professional social media presence online. Twitter, in contrast, is a mixed-use microblogging platform where individual posts are limited to 140 characters or less. Many lawyers use Twitter for personal purposes, but many lawyers and law firms also use Twitter in their daily legal practice for business development, research, and investigative purposes. YouTube is one of the largest and most popular video sharing websites in the world. It also happens to be the second largest search engine on the internet behind Google, which makes it one of the most powerful online resources for publishing and finding practice-related video content. Chances are, if you haven't personally used or encountered one or more of these forms of social media, you will encounter them in the very near future, because the technology has become so pervasive that it implicates virtually every aspect of the law and the practice of law. You may not be aware that there are even a few social networking services that are marketed directly to the legal profession. Martindale Connected, for example, is a social networking site marketed exclusively to lawyers to connect and share information with each other on law-related subjects. Legal On-Ramp is a social networking service originally designed by in-house counsel for in-house counsel to share information and ideas. Avo, on the other hand, is a consumer-facing lawyer rating site and interactive forum designed for lawyers and consumers of legal services to connect. LXBN, or the LexBlog Network, is a very robust network of law-related blogs covering developments in many different practice areas. These and other social networking sites, focused on the law and the legal profession, are providing lawyers with unparalleled opportunities for publishing, connecting, learning, and marketing to clients and prospective clients. Despite the widespread availability and popularity of social media, the legal profession as a whole has been relatively slow to adopt these technologies for professional or business development purposes. However, many lawyers and law firms do now regularly utilize social media for a variety of different purposes, including contact management, content curation, business development, marketing, research, fact-finding, and even getting the latest breaking news. But because these technologies have become so pervasive in our everyday professional and personal lives, we must ask ourselves how the Florida Rules of Professional Conduct apply to the social media activity of legal professionals. The answer is, it depends. The rules apply, or potentially apply, in many different ways and circumstances. Here we will focus on 10 potential ethical pitfalls that you may encounter in your social media engagement.
There are 3 primary takeaways from this webinar. First, the intersection between legal ethics regulation and social media is largely uncharted territory in Florida and outside this state. The landscape is constantly changing. It is therefore important to keep an eye out for important developments in this area. Second, the rules of professional conduct that apply to your day-to-day legal practice also apply to professional and business activities on social media. Many people think that because this is new, exciting, and emerging technology, that the rules that we're familiar with don't apply, but they do. And third, all of this requires active consideration of what you're doing with social media, how you're doing it, why you're doing it, and how all of the ethics rules potentially apply in light of all of those considerations.
But before we talk about the specific ethical pitfalls, let's first set the stage by talking about the rules governing lawyer advertising. Many of the lawyers with whom I've spoken about social media are surprised to learn that the advertising rules are even a consideration when using social media because they tend to think of the rules as applying to traditional forms of advertisement like billboards, bus benches, phone book ads, television ads, radio ads, printed flyers, direct mailings, and the like. But legal ethics regulators, including the Florida Bar, quite often view lawyer social media usage through the prism of lawyer advertising because of the capacity of this technology to facilitate contact and communication between lawyers and consumers of legal services. In 2013, the connection between social media and the lawyer advertising rules became very clear when the Florida Supreme Court comprehensively amended Subchapter 4-7 of the Rules of Professional Conduct, which governs lawyer advertising. Although the rule changes became effective May 1 of 2013, many Florida lawyers and law firms are unaware of how these rules apply to social media usage. If you are a Florida licensed lawyer who uses social media or who intends to use social media, you should be sure to familiarize yourself with the current requirements for lawyer advertising in Subchapter 4-7 because there were many substantive and technical changes that became effective in May of 2013 that you likely do not know. Additionally, if you work for a law firm that has a marketing department that handles your social media presences, or if you contract with an outside public relations firm or marketing firm to handle your social media presences, you should be sure that the individuals who are posting to social media on your behalf or on your firm's behalf are fully aware of all advertising requirements in effect since the 2013 rule changes. I'm often asked what the terms advertisement and advertising mean for purposes of the lawyer advertising rules. Following the 2013 rule amendments, the terms advertising and advertisement as used in Subchapter 4-7 are defined to refer to all forms of communication seeking legal employment, both written and spoken. This is obviously a very broad sweeping definition that encompasses a broad spectrum of online activity motivated by the desire to seek legal employment. Additionally, the rules expressly apply to all forms of communication in any print or electronic forum, including but not limited to internet, websites, social networking, and video sharing media. Prior to the 2013 rule changes, the rules did not specifically reference social networking sites or video sharing sites as being subject to the advertising rules. Now, however, social networking sites and video sharing media are expressly included within the scope of the rules. So there is no question that the advertising rules are a consideration whenever lawyers and law firms use social media. Now let's cover a few specific highlights of the lawyer advertising rules and their application to social media. Before the 2013 rule changes, websites were considered passive information provided to prospective clients on request, and as such, they were not regulated to the same extent as more traditional forms of advertising like print ads or television ads. The 2013 rule changes made it very clear that lawyer websites and forms of communication made through social networking sites and video sharing sites are subject to the advertising rules and should be regulated to a greater extent than they were under the prior rules. For example, a lawyer's LinkedIn profile is technically both a website and a social networking site subject to the advertising rules. Under the definition of advertisement, communications seeking legal employment made through LinkedIn would constitute advertising. I'm often asked whether social media profiles or posts must be submitted to the Florida Bar for approval before they are published, like other forms of advertisements. The answer under the current rules is no. While it is true that some advertisements must be filed with the Florida Bar for approval before their planned use, information contained on a lawyer's internet website is expressly exempt from the filing and prior approval requirements. Therefore, social media pages and internet websites do not need to be filed with the Florida Bar for approval. That is not to say that you can never submit web content for prior approval or an advisory opinion before the content is published. Advertisements that are otherwise exempt from filing and prior approval may nevertheless be submitted for an advisory opinion concerning compliance. But the rules state that a lawyer may not file an entire website for review. Instead, lawyers can seek advisory opinions concerning the compliance of a specific page, provision, statement, illustration, or photograph on a website. This is an important option to remember because certain social media content like discrete blog posts or online video may potentially raise compliance issues for which the responsible attorney or law firm may want to seek an advisory opinion before posting. The 2013 rule changes established what are sometimes referred to as grace periods for curing certain types of noncompliance with the advertising rules. These grace periods are relevant to lawyer and law firm social media usage because they provide at least some mechanism for bringing otherwise non-compliant social media content into compliance after the Florida Bar notifies the responsible attorney or law firm that there's an issue. Under the rules, if a lawyer obtains pre-approval from the Florida Bar for certain social media content that constitutes advertising, but it is later determined that the advertisement does not in fact comply, the responsible lawyer has 30 days to stop disseminating the advertisement. However, for any portion of an internet website for which the lawyer did not obtain pre-approval from the Florida Bar, the rules provide for a 15-day grace period for curing any noncompliance, specifically with Rules 4-7.14, which governs advertisements deemed to be potentially misleading, and Rule 4-7.15, which governs advertisements deemed to be unduly manipulative or intrusive. This 15-day period is triggered by the Florida Bar's sending of a notice of noncompliance to the lawyer's official bar address. Importantly, however, this 15-day grace period only applies to noncompliance with Rules 4-7.14 and 4-7.15 specifically. It does not, for example, apply to noncompliance with any of the other advertising rules governing advertisements that are deemed to be inherently deceptive or misleading. For that reason, the so-called grace periods provided by the rules have a fairly narrow applicability. The 2013 rule amendments also established a new standard for evaluating references to past results and comparisons of lawyers or statements, words, or phrases that characterize a lawyer's or a law firm's skills, experience, reputation, or record. Under the rules, these types of representations must be objectively verifiable. But what does objectively verifiable mean in this context? The comments to Rule 4-7.13 suggest that objectively verifiable means that the representations in question must be true and capable of being factually substantiated. The comments explain, for example, that lawyers and law firms cannot claim to be the best, the finest, or second to none in a field of law because those claims are not objectively verifiable. So when using social media as a lawyer or on behalf of a law firm, it is important to keep these restrictions in mind and be cautious about how you characterize yourself, your practice, and any past results. And even if you comply with all of these limitations, other social media users with whom you are connected may not be aware of these limitations and may make comments or representations on your social media pages, like your Facebook wall or your Twitter feed, that are impermissible. For example, you may decide to post information about a recent outcome obtained on behalf of a client that fully complies with all the requirements of the rules, but your mom may comment or reply something like, "Congratulations, you're the best lawyer in the world." That characterization of your skills as a lawyer is not objectively verifiable and so cannot be adopted or republished by you. As a result, you would need to delete the non-compliant comment or ask your well-intentioned mom to delete it herself if you are unable to do so. The rules also require that advertisements identify a lawyer or a law firm responsible for the content of the advertisement. This means that for social media profiles or posts used for advertising purposes, the profile and each post should identify an individual lawyer or law firm responsible for that content. This becomes an issue where, for example, a lawyer or a law firm uses a false, fictitious, or trade name as a social media handle or username instead of the lawyer's or the law firm's actual name. In such instances where it is not clear to any public viewer which lawyer or law firm is responsible for the advertising content being posted on the social networking service, some additional effort to disclose that identifying information in the profile or in the individual posts is required. Another technical requirement under the advertising rules is that all advertisements must disclose the geographic location of a bona fide office of the lawyer or law firm. The geographic disclosure may be by county, city, or town in which the lawyer or law firm maintains a bona fide office. For purposes of the rules, a bona fide office is defined as a physical location maintained by the lawyer or law firm where the lawyer or law firm reasonably expects to furnish legal services in a substantial way on a regular and continuing basis. When applied to social media, this rule means that lawyer and law firm social media profiles and posts used for advertising purposes must contain the necessary geographic disclosure of the location of a bona fide office. When doing so, however, it is permissible to use common abbreviations. This is particularly helpful for tweets on the microblogging service Twitter that are limited to 140 characters in length. I'm often asked whether it is sufficient to include the geographic disclosure in a social media profile, but omit it from the individual posts made through the same account. The answer for now is, it's unclear. Literally construed, the rule would appear to require geographic disclosure in individual social media posts, meaning individual tweets on Twitter, individual posts to your Facebook wall, and individual blog posts, for example. The Florida Bar has not issued any formal guidance on that point as of the date of this webinar. Unless or until the Florida Bar issues formal guidance on that issue, it is prudent to assume that individual social media posts that constitute advertisements must contain the requisite geographic disclosure. The good news is that the requirement is not terribly onerous. It is as simple as appending the words Office Tampa if, for example, you actually maintain a bona fide office in Tampa. If your office is located in a county, city, or town with a long name, it is permissible to use a commonly recognized abbreviation to save character space. The city of St. Petersburg, for example, might be abbreviated as St. Pete. Now that you have an overview of some of the advertising rules that apply to lawyers and law firms using social media, let's talk more specifically about the 10 potential ethical pitfalls associated with social media. The first pitfall is distinguishing between personal and professional use. One of the threshold challenges Florida lawyers face when jumping into social media is drawing a distinction between personal use and professional use. Some legal marketers advise lawyers to keep their personal social media activity segregated from their professional social media activity by maintaining dual profiles. Other legal marketers advise lawyers to maintain a unified online identity, mixing personal and professional social media content into one online persona. Individual lawyers may even have personal preferences as to which approach they think is more appropriate. But why is this distinction relevant for legal ethics purposes? Because, according to the Florida Bar's Standing Committee on Lawyer Advertising, professional use of social media is subject to the advertising rules, whereas purely personal use is not subject to the advertising rules. Since 2009, the Standing Committee has published 2 sets of guidelines relating to social networking sites and video sharing sites. The guidelines have been periodically revised and updated over time, including the most recent revisions in April of 2013. These guidelines say that professional use of social media to promote a lawyer's or a law firm's practice is subject to the advertising rules. In contrast, personal use, solely for social purposes to maintain social contact with family and close friends, or solely for purposes that are unrelated to the practice of law, is not subject to the advertising rules. The guidelines also make clear that lawyers are responsible for all content posted on their own social networking pages, including non-complying posts by third parties. This means that lawyers are responsible for policing their own social networking pages to remove non-complying posts made by their social networking connections. And yes, this includes well-intentioned posts by friends and relatives who may inadvertently post statements on your social media pages that do not comply with the advertising rules. The practical difficulty many lawyers face is that it is incredibly easy to blur the lines between solely personal use of social media and promotional use of social media, especially when casually commenting on day-to-day activities, including personal activities and work-related activities. There is an expansive gray area between purely personal use of social media and what we might consider more traditional or obvious forms of advertising, like publicly tweeting, "Call me at 1-800-555-5555 if you've been involved in a car accident." It is important to keep in mind that even though you may think you are using social media for personal purposes in a way that's not subject to the advertising rules, if a post promotes you as a lawyer, promotes your legal practice, or promotes your law firm's practice, then the post may be deemed an advertisement subject to the advertising rules. Notably, however, Rule 4-7.18 provides exceptions for communications to other lawyers, family members, current clients, former clients, or persons with whom the lawyer has a prior professional relationship as a professional. These exceptions provide a safe harbor for communications to individuals falling within one or more of these categories. But not every prior professional relationship is sufficient to fall within these exceptions. To qualify for an exception, a prior professional relationship requires that the lawyer personally have a direct and continuing relationship with the other person in the lawyer's capacity as a professional. The comment to Rule 4-7.18 says, for example, that a lawyer who is a patient of a doctor does not have the professional relationship contemplated by the rule because the lawyer is not involved in that relationship in the lawyer's professional capacity. Additionally, merely serving on the board of a charitable organization with another person or sharing membership in an organization in common with another person is not enough, without additional facts that would give rise to the type of direct and continuing professional relationship that is contemplated by the rule. Pitfall number 2, false or misleading statements. The rules of professional conduct prohibit lawyers from making false or misleading statements. This includes statements made through social media that may be deemed false or misleading. Importantly, these prohibitions apply even outside the context of legal advertising. For example, Rule 4-8.4c broadly prohibits lawyers from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. This pitfall arises in many seemingly innocuous ways. For example, many jurisdictions, including Florida, specifically prohibit lawyers from claiming to be experts or specialists in any area of the law, or using any similar terminology unless the lawyer has a bar-approved certification. Even with a bar-approved certification, the rules restrict how that certification can be represented to the public. Nevertheless, several professional social networking sites will automatically characterize certain users as experts or specialists in their area of practice. The problem for lawyers is that these social networking sites may brand the lawyer as an expert or a specialist, or as having expertise or a specialization in the law, sometimes without the lawyer's knowledge. When using any social networking site for professional purposes, be mindful of any functionality of that site that may label or brand you as a so-called expert or a specialist in your field. If you do not have a bar-approved certification, you likely cannot use that function on the site. And if you lack the ability to avoid that function altogether, it may not even be possible for you to participate on that social networking site. Even if you have a bar-approved certification, you should scrutinize how the site characterizes your practice to confirm that none of those characterizations exceed what the rules of professional conduct would allow. Also, keep in mind that currently, there is no provision under the rules for a law firm, as opposed to an individual lawyer, to claim expertise or specialization in an area of the law. So if you establish a social networking page or profile on behalf of a law firm, Avoid any functionality on that social networking service that may brand or characterize the law firm using those particular terms or any similar terms. This second pitfall also arises in connection with online testimonials and endorsements. The comments to Rule 4-7.13 define a testimonial as a personal statement, affirmation, or endorsement by any person other than the advertising lawyer or a member of the advertising lawyer's firm regarding the quality of the lawyer's services or the results obtained through representation. Many social networking sites like LinkedIn, Avo, and even Facebook allow other users to post public testimonials, endorsements, or ratings of a lawyer or a law firm. In the case of LinkedIn, testimonials and endorsements are heavily promoted by the company and are featured prominently on user profiles. In addition to allowing narrative testimonials, LinkedIn also allows users to endorse each other very easily through a single mouse click by what's called a one-click endorsement for skills or experience that either the lawyer has identified in the lawyer's profile or that LinkedIn's algorithm guesses is appropriate for that lawyer based on other available information. Under the rules, testimonials for lawyers and law firms were traditionally prohibited in Florida until the advertising rules were amended in 2013. Under current Rule 4-7.13, testimonials are allowed, but they must comply with several strict limitations. First, a testimonial must concern matters on which the person making the testimonial is qualified to evaluate. In this regard, the comments to Rule 4-7.13 state that clients as consumers are well qualified to opine on matters such as courtesy, promptness, efficiency, and professional demeanor. As such, testimonials on these matters, as long as they are truthful and are based on the actual experience of the person giving the testimonial, are deemed beneficial to prospective clients and are permissible. That's not to say that clients may not be qualified to evaluate other matters in a testimonial. The comments merely acknowledge that there are certain qualities of a lawyer that all clients are qualified to evaluate, so long as the testimonial given is based on actual experience. Second, a testimonial must reflect the actual experience of the person making the testimonial. Third, a testimonial must be representative of what clients of the lawyer or law firm generally experience. Fourth, a testimonial cannot be written or drafted by the lawyer. Fifth, a testimonial cannot be given in exchange for something of value. Sixth, a testimonial must include a disclaimer that the prospective client may not obtain the same or similar results. Any testimonial or endorsement that does not comply with these requirements cannot appear on a lawyer's social media page. For example, if a relative decides to endorse you for your skills in handling M&A transactions or employment litigation matters, but he or she has never actually worked with you in your capacity as a lawyer on either type of matter, then you cannot allow that endorsement to appear on your LinkedIn profile because the endorsement is not based on the actual experience of the person giving it. Additionally, if you are a personal injury attorney who never handles contract dispute matters, and another LinkedIn user endorses you or gives a testimonial stating how good you are at handling contract dispute litigation, you similarly cannot allow that endorsement or testimonial to appear on your profile because you do not actually do that type of work for clients. All of this requires careful self-monitoring of lawyer and law firm social media pages to make sure that third parties and clients do not post testimonials or endorsements that the lawyer or the law firm is ethically prohibited from displaying to the public. At times, this can be a time-consuming annoyance because of how popular the one-click endorsements have become on LinkedIn. The good news is that LinkedIn allows lawyers to reject endorsements on an individual basis, or lawyers can simply turn off one-click endorsements altogether in the LinkedIn privacy settings if they do not want to invest the time to police each individual endorsement they receive. Pitfall number 3, improper solicitations. The rules impose many limitations on a lawyer's or a law firm's ability to solicit legal employment. Under Rule 4-7.18, a solicitation includes a communication directed to a specific recipient seeking professional employment from a prospective client when a significant motive for the lawyer's doing so is the lawyer's pecuniary gain. Applying this definition, a friend request or other invitation to join a social network used for business development purposes could potentially constitute a prohibited solicitation if sent to a non-lawyer prospective client with whom you do not have an existing exempt relationship, like a relative, a current client, a former client, another lawyer, or a person with whom you have a prior professional relationship as a professional. This requires lawyers to think about the nature of their relationships with other social media users before initiating any communication to determine whether that communication might constitute a prohibited solicitation. As a practical matter, many social networking services make it extremely easy to connect with other users by allowing you to import your electronic contacts list in your webmail account or your Outlook, so that the system can automatically search for and send batch invitations to those individuals on your behalf. Using these automatic features is an activity fraught with peril for lawyers because the system may automatically send a social networking invitation to someone whose name appears in your contacts lists, but with whom you do not have a sufficient prior personal or professional relationship to qualify for an exception under the non-solicitation rule. Allowing the system to send out a social networking invitation to that person may constitute a prohibited solicitation. Moreover, if the system sends the person repeated reminders within the social network or separately by email, the potential ethics violation may be compounded several times over. As a rule of thumb, you should always think before you attempt to connect with anyone on social media and, in doing so, give serious consideration to the nature of your relationship with that person. Also, beyond compliance with the non-solicitation rules, it may not be prudent to upload your complete contacts files to a third-party social networking service because you have no way of knowing or controlling exactly how the social networking service will use that information now or in the future. A special caution about email communications. It is important to keep in mind that invitations to view or join a social networking site should comply with the rules relating to direct email solicitations if sent to a non-lawyer with whom you do not have an existing relationship. Many social networking sites, like Facebook and Twitter, do not allow users to customize email communications that are generated automatically by the social networking system when an email invitation is sent. So, in such instances, ethical compliance may not even be possible. Pitfall number 4, friending judges or mediators. Different jurisdictions have different opinions or rules regarding what a judge can or cannot do on social media. A series of Florida judicial ethics opinions have concluded that judges in this state cannot be Facebook friends or LinkedIn connections with lawyers who may appear before them. It is a very broad prohibition. These ethics opinions emphasize the fact that social networking sites like Facebook and LinkedIn allow judges to selectively accept or reject friend requests or networking invitations. There's also an ethics opinion that cautions judges about the ethical issues and constraints in using Twitter. Keep in mind that in jurisdictions like Florida, where a judge may be ethically prohibited from friending lawyers on Facebook or other social media, the restriction is generally reciprocal because individual lawyers, likewise, cannot facilitate or induce judges to commit ethical violations. Interestingly, an ethics opinion by the Mediator Ethics Advisory Committee found that mediators may designate mediation clients or attorneys who participate in mediations with the mediator as friends on a social networking site like Facebook, and permit clients or attorneys to add the mediator as their friend. However, mediators must determine whether the nature of their relationship with an attorney or a party through social media represents a potential conflict of interest or would impair the mediator's impartiality. If so, the mediator must disclose the relationship so that the parties can evaluate whether there is a conflict of interest, or the mediator must not mediate the matter. Pitfall number 5, commenting about judges or pending matters. The Florida Rules of Professional Conduct prohibit a lawyer from making extrajudicial statements that a lawyer reasonably should know will have a substantial likelihood of materially prejudicing an adjudicative proceeding. The rules also prohibit lawyers from assisting another person to make such statements and require lawyers to exercise reasonable care to prevent investigators, employees, or other persons assisting in or associated with a case from making extrajudicial statements that are prohibited. So, lawyers and law firms must consider these restrictions before commenting about pending matters in social media, and exercise reasonable care to prevent others in their control from violating the rules through their use of social media. Because of these broad prohibitions, lawyers must be very cautious about blogging, tweeting, or posting comments about pending adjudicative proceedings. The same is true for lawyers' statements of opinion on social media about judges. The rules of professional conduct expressly prohibit lawyers from impugning the qualifications and integrity of judges by making statements that the lawyer knows to be false or with reckless disregard as to the truth or falsity of the statement. The rules also broadly prohibit lawyers from engaging in professional conduct that is prejudicial to the administration of justice. The best practice is to take the high road and not use social media as a forum for commenting about pending matters or judges. There's some precedent on this issue as it relates to blogs. In a fairly high-profile case in 2008, the Florida Bar publicly reprimanded a Florida attorney for posting negative comments about a judge on a legal blog. The citation to the related materials can be found in the substantive outline that's made available in connection with this webinar. Pitfall number 6, inadvertently creating attorney-client relationships. Attorney-client relationships can be formed over the internet through electronic communications, including social media communications. If they are not cautious, it is possible that lawyers and law firms may inadvertently create attorney-client relationships with non-lawyer users of social media when engaging in substantive conversations on legal issues or when discussing the possibility of forming a lawyer-client relationship with respect to a specific matter. It is a good practice not to engage in such communications through social media unless you intend to form a lawyer-client relationship with a prospective client. But if you do so, be mindful that you must also abide by all other rules governing the prospective client relationship, including maintaining the confidentiality of client information and clearing conflicts. For example, a public Twitter exchange or Facebook exchange with a prospective client regarding the client's specific legal needs and the possibility of forming a lawyer-client relationship would not comply with the rules regarding confidentiality because other users of that social networking service would have full access to the public communications involved. Pitfall number 7, inadvertently disclosing privileged information or work product. When posting through social media, it is important to consider whether or not the substance of your posts could potentially reveal confidential information, privileged information, or work product. If so, as a rule of thumb, do not post. It is important to remember that a lawyer's obligation to protect client confidences is not limited solely to protecting attorney-client communications or attorney work product against disclosure. Lawyers may become privy to a wide variety of confidential client information that cannot be disclosed without the client's consent, and in some instances, clients themselves may be legally prohibited from disclosing certain information to the public. Publicly traded companies, for example, may be constrained against disclosing information about a pending merger or acquisition or a new product launch. If you are a lawyer working on those types of confidential matters for a client, you would not want to post any information on social media that would violate the confidentiality of the client's information. Be aware that other sophisticated social media users can pull information from a variety of different sources and glean confidential information from posts using other publicly available facts, data, or information. So, for example, if your corporate client's industry is buzzing with rumors that the client is in confidential merger talks with another company, and the fact that you or your law firm represent the acquiring entity can be ascertained through other publicly available information like your law firm's own webpage or LinkedIn profile, even a vague reference in your social media post to working on the pending merger may be enough to alert a reasonably diligent social media user that the rumors of the confidential merger are true. Additionally, keep in mind that some social networking sites like Facebook and Twitter may, by default, geotag your social media content to let other social media users who have access to the content, including photos, know where you were in the world when that content was generated and posted. There may be instances where even your physical location at a given point in time should be treated as confidential, and you would not want to disclose that information. Pitfall number 8. Investigating and communicating with represented parties and unrepresented third parties. A lawyer cannot communicate with a person the lawyer knows to be represented without the consent of the represented person's lawyer. Moreover, lawyers cannot use agents or third parties to communicate on the lawyer's behalf or induce others to facilitate an ethical violation. So, for example, a lawyer cannot ask a paralegal to communicate with a represented party through social media when the lawyer himself or herself could not communicate with the same party through social media. This limits the ability of lawyers and law firms to use social media to communicate with or even to investigate represented parties. Be mindful of the fact that you may not know that a particular activity on a social networking site will generate a communication to a represented party, even if you did not intend to communicate directly with that party. LinkedIn, for example, has a feature that notifies users who has viewed their LinkedIn profile recently. So, if you visit the LinkedIn page of an investigative target while you are logged into LinkedIn, LinkedIn will tell that person that you viewed their profile. Presently, LinkedIn allows users to disable that feature in privacy settings, but if you choose to disable that feature, LinkedIn will no longer notify you who has viewed your profile recently. If you routinely conduct any factual investigation or searching of represented parties through LinkedIn, it is a good idea to disable that feature in your privacy settings so that the represented persons you are investigating will not be notified that you visited their LinkedIn profile. With regard to unrepresented third parties, there are a growing number of ethics opinions outside of Florida. As of the date of this webinar, however, there are no ethics opinions in Florida that address this particular issue. But the ethics opinions that exist outside of Florida generally have concluded that accessing publicly available or publicly viewable social media information of third parties is fair game. But sending a friend request to an unrepresented third party to gain access to non-public social media information without disclosing the lawyer's identity and reasons for seeking contact, or when doing so under a pretext or using a false name or false identity, is not permissible. Particular caution is warranted where the unrepresented third party is a juror or potential juror in a case, because the rules impose broad restrictions against lawyers communicating with jurors and potential jurors.
Pitfall number 9, multi-jurisdictional practice and unlicensed practice of law. The ethical implications and rules regarding multi-jurisdictional practice are complex. The bottom line is that lawyers and law firms must examine whether their activity online might be governed by the relevant rules in the lawyer's or law firm's home state, and possibly even other jurisdictions. Be mindful that friends, followers, or other social networking connections can read posts from anywhere in the world. A tweet, for example, has no geographic limitations in terms of the audience it can reach.
Pitfall number 10, friending opposing counsel. If you connect with someone through a social networking service, whether it be LinkedIn, Facebook, or Twitter, you must appreciate that that person, and depending upon your privacy settings and their privacy settings, potentially all of that person's other connections may have access to the information you post and may also have access to your social networking connections through you. Allowing an opposing lawyer into your social network and potentially allowing them access to your client connections gives them the opportunity to gather intelligence about you and potentially about your client contacts that they would not otherwise have. It's the social media equivalent of giving someone unfettered access to your Microsoft Outlook contacts or your Rolodex if you still maintain a Rolodex. You simply wouldn't provide that information to the opposing lawyer. So, accepting a social networking invitation from opposing counsel is not a decision that should be made lightly. Additionally, it may be prudent with every new engagement to verify whether your opposing counsel, the opposing party, or anyone associated with the opposing counsel or the opposing party are members of your existing social network. If so, you may want to consider severing that connection or blocking their access to your social media content, including the list of your other social networking connections, in order to prevent them from obtaining information and intelligence through your social network. If you're interested in learning more about the intersection between social media and legal ethics, please feel free to download the substantive outline being made available to all webinar registrants. In that outline, you will find information on 4 bonus pitfalls, including the use of pay-per-click, pop-up, and banner advertisements, conflicts of interest, more on testimonials and endorsements, and non-compliant posts by third parties.
I hope that you enjoyed this webinar as much as I enjoyed presenting it. Please stay tuned for the next installment of the Florida Bar Technology webinar series. Thank you.